Well, we have a nice quiet that's settled over the room, so we may as well get started. Thanks everyone for joining us. I'm Lee Nevens. I use they, them pronouns. I'm the immediate past president of the Canadian Bar Association BC branch, where I was the first trans and non-binary president in Canada. And I remain chair of the Canadian Bar Association's Gender Diversity Advisory Group. And then to make money, I'm senior litigation counsel for the Department of Justice based out of Vancouver. I say all that just to give you a little perspective on where I'm coming from as we enter the access to justice conversation. I've done a lot of work on multiple angles related to access to justice, but most of my experience has been advocating for improved access and improved inclusion for folks in the 2S LGBTQIA+ communities, and in particular people who are two-spirit, trans, non-binary, and gender diverse. Which is why I think Vero reached out to me and said, hey, can you moderate this panel? The topic is Nothing About Us Without Us, Rethinking Participation and Power in Justice. And I'm glad you've all joined us here today to talk about that. The panel explores how justice systems can better include people, especially those traditionally excluded or disempowered, as active participants in shaping, interpreting, and experiencing justice. Together, these panelists, who you're going to hear a lot from today, illustrate that justice is not only delivered to people, but can also be co-created with them. We have 4 excellent speakers for you today. Each is going to give you about a 10-minute presentation on their work. I have my little notes here, but they might go over here and there. Which leaves us with about 30 minutes for Q&A at the end. I urge you to think about questions as you listen to the presentations, but I ask you to hold the questions until the end. And we have a good amount of time for Q&A. We've preloaded about 3 questions to get the discussion going, but seeing how well the session went this morning, I think we'll have lots of questions for our audience. So first to our speakers, I'll give short bios to introduce them at the beginning of each presentation, but I want to save the time for substantive content. So if you want to see all of their credentials and amazing experience, you can check out the website for the more detailed bios. So we're going to start with Anne Levesque about advancing children's access to justice in Canada, lessons from non-judicial mechanisms. Anne is associate professor in the French Common Law program at the Faculty of Law at the University of Ottawa, where she holds the Gordon Henderson Chair on Human Rights. Her research and publications focus on human rights and public interest litigation, and is one of the lawyers who represented the First Nations Child and Family Caring Society in its human rights case leading to an historic victory in 2016, which affirmed the right to equality for more than 165,000 First Nations children. I said I was going to try not to embarrass people during the introductions, but yes, I think applause is certainly warranted. Over to you, Anne.
Thanks. I was noticing, and my colleagues were noticing, that more and more children were stepping up to be human rights defenders. So not just, parents asserting their rights or their guardians, but really, in climate change, for example, they were the ones acting as litigants. They're the ones pushing adults to affirm their human rights. Same thing for reconciliation. You mentioned the Caring Society case. Kids were really at the forefront of pushing for equality and saying this is unacceptable what the government of Canada is doing to kids. They were organizing protests. So Mona Paré and I got together and started thinking about how do courts and administrative tribunals respond to this, that courts are now, children are now acting as human rights defenders, and what do we need to adapt to this reality? So we wrote a few papers and looked at what courts are doing and how responsive they are to their policies, their practices, their rules of procedures to kids stepping up and trying to assert their human rights. And then we got a SHRC grant to look at administrative justice. So and we looked at the Canadian human rights tribunals and commissions all over Canada, child advocates, ombudsman's offices, and the Committee on the Rights of Child, and looked at their policies, practices, procedures, their rules of procedures, and also their case law. And finally, we sent a survey at the end to see were they turning their minds to adapting their procedures for kids? Were they trying to involve children in a meaningful way? And you'll hear me say that it was really the surveys that were the most instructive of this research. So my role was looking at what human rights commissions and tribunals were doing in Canada to adapt to children. For those of you who don't know, human rights tribunals are, and commissions created under anti-discrimination laws. Commissions have different roles, but we were mostly concerned about the role of receiving complaints, discrimination complaints, and then tribunals or commissions adjudicating complaints and rendering decisions involving kids. And again, not just kids, like parents filing complaints on behalf of kids not getting accommodation at school, but when kids were really acting as human rights defenders. Interesting enough, I don't know if people know this, but most of human rights laws in Canada don't protect against age discrimination against kids. So they actually permit discrimination against kids on the basis of age. Though that was a bit of the backdrop of the research, but it was still, and that doesn't mean that kids aren't protected. So kids still are protected against discrimination on other grounds, for example, race and disability, sexual orientation, gender identity, but age in particular. I think it is a ground of discrimination against kids that is invisible for a lot of people, that it's so normalized in society to discriminate on the basis of age against kids, that I think even human rights commissions and tribunals, where their mandates is to create equality in Canadian society, don't necessarily think about childism in their policies. So where we're at in the research is we've gathered all this data, we've done the case law analysis, the policies, practices, and procedures, and we got the survey results. And in general, I mean, there are some good initiatives coming out of certain provinces, but what we found is a lot of comments in the surveys seeing that in general, I mean, if I was to summarize, I think children aren't viewed as people or rights holders. What we've heard was there are few initiatives geared directly at kids. There were some initiatives aimed at teachers, for example, or schools, and schools as a site of education and empowerment on human rights is a good idea. It's a good principle, and access to justice is meeting people where they are. But we also know that schools can be a site for discrimination for certain kids, so it shouldn't be viewed as a substitute of direct initiatives for children. We also saw, a few policies, practices, or rules adapted or specifically to involving children in hearings, for example. Even I looked at the complaint today to make sure I wasn't misspeaking, but the Canadian Human Rights Tribunal form for filing a complaint doesn't say, are you a guardian? Are you filing on behalf of a child? So my worry about that is that people filing on behalf of a child that can't file a complaint on their own, might receive the message that they're not allowed to file a complaint because age isn't protected, that they're not protected under other grounds, so that's problematic. Mediation policies or adjudication processes, very, very little to do with children. That being said, if for those of you who know the Caring Society case, it's a case from the Canadian Human Rights Tribunal, and we actually have a paper coming out very shortly that examines the case as a case study about how even though administrative tribunals don't have specific rules of procedure for adapting their procedures to kids to allow meaningful participation, they still have broad discretion as masters of their own house in how to adapt their procedures. And that case for me is just a shining example about meaningful participation of kids. Kids were allowed to sing at the beginning of the hearing, read poems. There were ceremonies for kids, and it was really children-led initiatives and child-appropriate and age-appropriate participation for kids. So I think just because the rules are silent, it doesn't mean that tribunals don't have the discretion, but the importance is, in thinking about whether they're turning their minds to this issue. Now, I said a bit about the survey. The survey asked questions about, what initiatives are you taking for kids? What special measures do you take when kids are calling? What processes do you accommodate? And I mean, we're still analyzing the data, but what we heard is a lot of commissions and tribunals saying, well, our mandate is not really regarding kids. And that was very upsetting to me. And it reminded me of like the argument that Via Rail made back in the day when they bought inaccessible carts, and they said, well, we're responsible for the public and not people with disabilities. And then the Supreme Court properly said, you know, people with disabilities are the public, they're members of the public. But it was surprising to see some of these responses from institutions that are meant to represent minorities to carve out a minority and say that they're not part of our mandate. So some of the answers alluded to that. Some also said that kids don't understand our processes, so it's hard to work with them. And again, from a user-based perspective, you know, a more accessible way to look at that would be like, we need to make our system more accessible to kids. If they don't understand, it's our problem. It's not their problem, right? We wouldn't say that about people with disabilities or a person with a language barrier. And then finally, a lot have said, well, kids don't contact us. So, you know, and again, is this a chicken and the egg thing? Are kids not contacting commissions and tribunals because they don't think they have human rights? And then are adequate measures being taken to inform kids about their human rights? So we're still in the process of analyzing the data and working on a paper to make recommendations, but I thought I'd offer you guys a sneak preview, and maybe hopefully some people will read our paper. In terms of recommendation, I think this is going to sound very basic, but I think we need a shift in seeing kids as rights holders. It sounds very basic, but I think age of discrimination against kids is so normalized. Obviously, I'm not advocating that my 8-year-old should be able to buy booze at the LCBO, but just a blatant exception of all age discrimination, I found really unacceptable, and it does send the message that ageism is acceptable and tolerable, and it renders this kind of discrimination invisible. So I think kids are showing us the way. As they're stepping up to be human rights defenders, it will force change. They're bringing these lawsuits. They're the ones talking to politicians, organizing protests. So I think tribunals will need to adapt. But in terms of recommendations, seeing children as rights holders and rights bearers, thinking about how we can adapt our process to them without making generalizations based on arbitrary age cutoffs. And finally, and this is going to come out probably in all the presentations, but data, like a lot of the tribunals and commissions don't gather any data relating to age, even though they'll collect on other grounds of discrimination. So it really is kind of the invisible ground of discrimination in a lot of tribunals. So that would be just, I think, a first step in identifying ageism and ageism practices, and also having people think about it, and then accountability. Now, just, the unanswered, I'm out of time, so we'll talk about this later in the questions. No, that's good. That's it. Okay. Yeah.
Thank you very much, Anne. I have many thoughts and questions about what you just said. I'm sure everyone else does as well, but I'm going to take my own advice and hold them for the end. Next up, we have Charlene Moore, KC, on advancing human-centered justice, lessons from the Restorative Inquiry and Nova Scotia Legal Aid initiatives. Charlene is the CEO of Nova Scotia Legal Aid, which she originally joined in 1999 as a family lawyer. Over to you.
Well, that really dates me.
I apologize. Earlier.
Hi, everyone. I'm really glad to be here. I realized going through my slides last night that I have more than 10 minutes, so I'm going to try and stay on track, and I have a tendency to go off script. So I'm really working hard to get my key points across. I wanted to share for a legal aid later like myself, that's how we think of ourselves when we've been with an organization for as long as I have. You can't practice without hope. You have to hope that in addition to representing your clients as effectively as you can as an advocate in the traditional justice system, that you also have the opportunities to affect change. And sometimes that can be really difficult because our systems are so resistant to change. And hope is what keeps you going. So I think that's really critical, and when I heard it yesterday when we were at the reception, it just reminded me of how important it is for all of us, because in the face of like increasing fiscal restraints and uncertainties and pressures on us to deliver in core areas of service as a legal aid organization, the opportunities to think outside the box, to innovate, become much more challenging for us. I also wanted to highlight that our province has been the subject of a number of commissions, most recently the Mass Casualty Commission. And that had a significant number of recommendations that came out as a result of that process. And Nova Scotia Legal Aid was one of the participants in the process, and we're still trying to digest how it is that we need to respond to those recommendations. But the two inquiries that I referred to in the presentation, and I actually don't know how to use this. Okay. The Nova Scotia Restorative Inquiry and the Donald Marshall Jr. Royal Commission. I reference them because the Donald Marshall Jr. Commission had specific recommendations for Nova Scotia Legal Aid. It was released in 1989, and the government never took up those recommendations, didn't invest in legal aid so that we could respond in a meaningful way. With the Nova Scotia Restorative Inquiry, the same. It was released in 2019. There was a task force that was put together. It resulted in 3 reports to and a final report to the legislature in 2021. But again, the connection between government and investing in legal aid to be responsive, because we represent most of the families that are involved in child protection. Really didn't make that connection. So it connected to government, obviously to Department of Community Services and Department of Justice, but it didn't make the connection to the role that we played within the justice system. Again, we were a participant in that inquiry, and I just referenced their definition of human-centered as intentional approaches that place experience and needs of people at the core of what institutions should be doing, so putting people first, not institutions first, and moving beyond kind of the transactional service delivery that is kind of typical of our traditional justice system, and thinking about ways that we can represent people and support them where their dignity, agency is most important, and where relationships really are the foundational element of what we do. And if I could, one of the thoughts that I had is that both inquiries highlighted that our justice system for many of the most vulnerable is unjust. Their participation and experience of it is that it is an unjust system in which they experience. And for Donald Marshall, he, at every step along the way, experienced injustice, and including the response and the role that Nova Scotia Legal Aid played. So if we're going to have just justice systems, we need a just society that supports that. So systems that are fair and human-centered, that promote human dignity, fairness, and sustainability. And at the heart of that is communities. I think that sometimes we direct all of our resources into where it costs the most, which is the court system, when really we should be directing most of our resources and time into communities where most of the real work is done. And I think if we focus at the community level to support early intervention, prevention, and solutions, we are strengthening communities, and they can impact leadership, because those who control the system, that can make the changes, like to stay in office, and they will respond to what strong communities can advocate for. So when we build knowledge and connection within communities and with those working within the justice system, we can respond more timely and effectively. So that's kind of like my pitch. But so what did that mean for us as legal aid in terms of what could we practically do on the ground? Because for most of our clients, when you, how can you feel safe and know that you are heard and seen if you don't see yourself represented within the organization that is trying to best serve your needs at sometimes the most difficult time in your life, whether it's a criminal matter or a child protection matter or a family matter. So the first step that we took because government was not going to fund us, was we decided that we would create an Indigenous social worker role. So in 2015, we created that position without government funding. The primary focus was to support Indigenous parents in child protection proceedings because the Mi'kmaq Legal Support Network was providing great service to clients that were involved in criminal proceedings. So we chose to focus our resources on child protection, where there is in Nova Scotia an overrepresentation of Indigenous families. And where possible, we help with family and social justice matters. It supports Nova Scotia clients across the province. I worked closely with Crystal. I can say she's a phenomenal person. She's three kind of key areas that she provides service in is client service, community engagement, teaching, and leading. We were lucky because we had a Treasury Board review soon after we had introduced that role, and so we received funding to ensure that we could maintain that position. With the African Nova Scotian social worker role, we had to apply for funding through the Law Foundation of Nova Scotia. We received it for 3 years. We then had to advocate to government to continue to fund it. We don't have the resources really to do the research and evaluation that we need to do to show how impactful these roles can be, not just in the justice system, but within community and for clients. Oh my God, 3 minutes. So it highlights the important role of data collection and evaluation, and legal aid plans like ours do not have the resources to do that. So we have to work with what we have, and we often have to rely on qualitative data and the support from others in the justice system. And there was a significant support for Charnel's role. So both Crystal and Charnel have developed strong relationships within community and within the with the judiciary as well as other justice partners. And so they have a lot of respect. They've spent the time developing those relationships in community. They serve in a lot of boards and are involved in a lot of conference and training. And so with that kind of support, we were able to obtain permanent funding. She has very similar roles as Crystal does, and in fact, sometimes they work together because some of our clients identify as both Indigenous and African Nova Scotian. I'm going to skip ahead to the prison law support worker role because this is a gap of unmet needs for a lot of people in custody. We are serving a sentence or are remanded. We didn't have the resources to provide full service, so again, we had to look for funding elsewhere, and so we applied through the Justice Partnership and Innovation Program. That position was piloted in 2022. We finished 4 years. Because of fiscal restraints and a 3% staffing reduction that we received, we are applying for continued funding to maintain that role with our organization. Susan is also someone who's developed and spent the time developing relationships with community and with those within the justice system. So when she asks people to show up, they show up. They come and they work together to find practical solutions. After 4 years, she had, the data we were able to collect, because our case management system does not really work to track this type of work that people do. We're kind of really geared towards court outcomes. But some of the data that I could share is that she had 2,312 service requests. So she travels regularly to all the correctional facilities in Nova Scotia, federal and provincial. She works on bail, sentencing, parole, and appeal, family, immigration, social justice supports. She helps a lot of self-represented litigants prepare for matters. She connects them with lawyers. She also facilitates access to GLADU reports and assessments. She does a lot, is involved with community transfer applications and assists with culturally informed release and reintegration plans. This is not the type of work or roles that government normally would fund for us to do as a legal aid plan. But they have a tremendous impact in moving forward if we're thinking about a human-centered, people-centered approach to increasing access to justice for the most vulnerable. And then lastly, quickly, 30 seconds, Sebago-Nageote Legal Aid Office is one of the things I'm most proud of. It came from community. So the members of Council came and approached us with a plan. the clients in Siboney community, the courthouse is 5 minutes away. Our legal aid office was over an hour away in the other direction. People often had difficulty finding transportation, traveling to the office to meet with lawyers. It was often very difficult. Sometimes they were hitchhiking. It didn't make any sense. It was us creating a response that was a system response and not thinking about what it was that our clients really needed. We worked together over the course of a year, completely led by the community in terms of what it was that they needed. They were involved every step of the way in the design of the office, in the hiring of staff, and in the development of a memorandum for ongoing consultation. And collaboration. We were able to do that because of extra federal funding that enabled us to put that project in place, as well as contributions from the community. And Jennifer Cox, who's our managing lawyer, because it's staffed by all Mi'kmaq lawyers and Mi'kmaq legal assistants, it serves the clients of Siboney within community and elsewhere in the province. I'm over, aren't I? If you can have a chance to go through what the impact is that she says that office has had, and just to share that when she talks about it, she becomes quite emotional, because she's worked in many offices within legal aid and other organizations, but there she said, they found themselves speaking in Mi'kmaq more often than they would have in any other circumstance. They used Mi'kmaq language in their correspondence with their clients and with court in a way that they never would have felt that it empowered them to be able to do so. And they felt really confident and secure in that. I am concerned about the future, because this is the kind of work we need to do research and data collection and evaluation to really explain what the impact of thinking in different ways of how we deliver service from a people-centered approach that continues to support the work that we do. So, sorry I went over.
No need to apologize. I think each of our speakers today could spend, a day doing trainings on these topics. So, and if you don't have time to ask your questions that you may have, we have the 2 days and lots of opportunities to network, I think, and to ask more questions. Suivant, nous avons Adeline Audrerie qui présente sur justice centrée sur les personnes, règlement des différends et rapports de pouvoir, le logement comme terrain d'analyse. Adeline est professeure au département de droit de l'Université du Québec. À vous, Adeline.
Merci. Et bonjour à toutes et à tous. Je vais donc présenter en français. Toutes mes excuses pour ça. My English is terrible. Et c'est plus naturel pour moi de parler de mes recherches dans ma langue. Donc, je vais aujourd'hui vous présenter les bases d'un projet de recherche que je mène grâce au soutien financier de la Fondation du Barreau du Québec et de l'Université du Québec en Outaouais. Alors, ma présentation, elle ne portera pas sur des résultats empiriques finaux, car le projet est en cours, mais plutôt sur les principaux axes de réflexion, puis les questions qui sous-tendent ce projet de recherche. Donc, l'objectif, c'était de de voir en quoi le logement constitue un terrain révélateur pour étudier le règlement des conflits en situation d'inégalité, de déséquilibre entre les pouvoirs. Donc, aujourd'hui, de mettre l'emphase, la lumière sur, la question du traitement des déséquilibres entre les parties dans les modes de résolution de différends comme la médiation, la conciliation, et de mettre l'emphase aussi sur le domaine du logement, qui est malheureusement, malgré l'actualité dans ce domaine, qui reste relativement peu exploré dans les thématiques de recherche. Donc, c'est de voir comment le logement est un terrain révélateur pour comprendre comment les modes de résolution des différends traitent ou peinent à traiter la question de la vulnérabilité, des rapports de pouvoir entre les personnes et des inégalités entre les parties. Et ces questions, elles sont d'autant plus importantes dans un contexte de crise du logement, on va en reparler, mais aussi de développement croissant des modes de prévention et règlement des différends. Est-ce que je peux avoir... Je ne sais pas comment ça fonctionne. Oh, thank you. Okay. Donc je vais commencer par quelques éléments de contexte. On voit que la crise du logement, elle transforme les conflits locatifs de plusieurs façons. D'abord, elle contribue fortement à l'augmentation du nombre de litiges et de différends dans cette matière, parce que là où des conflits autrefois s'éteignaient du fait du départ de la personne locataire de son logement et du fait qu'elle retrouvait un nouveau logement, dans un contexte où on peine à accéder au logement, ces conflits-là se cristallisent et se retrouvent devant les tribunaux. Donc c'est le fait d'avoir de la peine à se reloger qui va venir avoir un effet direct sur le nombre de litiges et de différends. Mais on voit aussi que ce constat, il influence le fait que la dimension structurelle de ces conflits est exacerbée parce que les logements sont moins nombreux, parce qu'ils sont moins abordables. Bien, ça vient renforcer les rapports de force entre les personnes en situation de conflit. Donc on va parler de tout ce qui est déséquilibre d'informations, des équilibres économiques et parfois institutionnels entre ces personnes. Et en même temps, on voit que le logement, c'est un bien particulier qui engage fortement la sécurité résidentielle des personnes, leur stabilité familiale, la santé mentale, santé physique, et aussi tout le volet inclusion sociale. Donc il y a derrière le logement différents volets qui font en sorte que ces conflits sont particulièrement intéressants à étudier dans un contexte d'inégalité. Puis on sait aussi, grâce aux études qui ont été menées dans ce domaine, que ça affecte particulièrement les communautés qui sont marginalisées dans notre société, qui sont plus vulnérables encore par rapport à la question de l'accès au logement et du traitement des conflits qui naissent du fait du logement. Alors, au Québec, on voit clairement cette incidence de la crise du logement sur les conflits locatifs. On voit une augmentation continue du volume des demandes introduites devant le tribunal administratif du logement. Ça ressort explicitement des rapports annuels qui sont publiés par le tribunal. Mais on voit aussi que le tribunal a une mission qui est explicite, qui est prévue par la loi, oui, de trancher les litiges, mais aussi de favoriser la conciliation entre les locataires et les propriétaires. Et dans les rapports, on voit que le nombre de dossiers qui sont fermés suite à une conciliation tendent à augmenter. Alors évidemment, ils représentent une faible proportion par rapport au nombre de litiges et d'audiences qui sont tenues au tribunal, mais si on regarde spécifiquement cette donnée, on voit que d'année en année, le nombre de dossiers fermés suite à une conciliation augmente. Et on sait aussi qu'il y a un projet au sein du tribunal administratif du logement du Québec d'automatiser certains volets de la conciliation, puis notamment d'automatiser le traitement des offres de conciliation. Ça pose une question. Oui, ça pourrait soutenir le développement de la conciliation dans ce contexte, puis dans cette institution en particulier, mais en même temps, ça pose la question de la capacité à adapter ces processus de conciliation à ces litiges particuliers qui sont marqués par l'inégalité entre les parties et les déséquilibres, et le risque d'occulter la question de la capacité des personnes à participer à la négociation, puis à négocier des ententes qui sont justes et équitables. Donc cette automatisation-là pose question, mais c'est un projet qui va voir le jour en 2026, donc on n'a pas encore de données sur la question. Donc j'avais mis les chiffres dans ma présentation PowerPoint où on peut voir cette augmentation entre l'année 2022 puis l'année 2025. On trouve aussi d'autres exemples intéressants de résolution des conflits en matière de logement à l'extérieur du Québec et du Canada, et notamment aux États-Unis. Puis j'aurais pas le temps de rentrer dans le détail, mais il y a eu beaucoup d'expériences de médiation locative comme moyen de prévenir les risques d'éviction des locataires. Plusieurs choses sont ressorties de ces programmes gouvernementaux mis en place dans un quand même grand nombre d'États aux États-Unis, notamment après la crise de la pandémie de la COVID-19. Autant on a vu des statistiques intéressantes qui montraient que quand même 90% des dossiers qui passaient par la médiation permettait effectivement de prévenir le risque d'une éviction du locataire, mais en même temps des recherches académiques qui ont montré aussi que oui, il y a des effets positifs, mais en même temps, il faut penser ces processus pour les adapter à ces situations-là d'inégalité entre les parties et qui doivent être conçus spécifiquement pour répondre aux besoins des personnes et aux risques de vulnérabilité. Donc, des programmes qui ont donné lieu à la fois à l'émergence de données qui montrent l'intérêt de recourir au mode de résolution des différends dans le domaine, mais aussi à l'importance d'adapter ces processus. Alors, dans ce projet, globalement, la question que je pose, c'est de savoir comment les mécanismes de conciliation et de médiation vont permettre de répondre ou de ne pas répondre adéquatement aux situations marquées par des asymétries entre les personnes, puis notamment dans ce domaine du logement. Puis cette question, elle vient interroger directement la posture du tiers médiateur ou conciliateur, puis son rôle dans le processus. Alors, j'ai deux axes principaux, puis je ne rentrerai pas dans les détails parce qu'évidemment, je vais manquer de temps. Mais le premier axe, c'est d'étudier les tensions normatives. Donc, les tensions normatives, c'est-à-dire comment, dans les cadres juridiques et déontologiques, on trouve des éléments qui vont demander à la fois aux tiers d'être neutres, de favoriser l'autonomie des personnes. Donc on voit que la neutralité ressort encore aujourd'hui fortement de ces normes, qu'elles soient juridiques ou déontologiques. Donc d'un côté, on lui demande de conserver cette posture de neutralité, mais d'un autre aussi de veiller à l'équilibre entre les personnes, à leur capacité à participer au processus. Donc c'est justement ce point de tension, et on pourrait dire presque de contradiction, dans les normes qui m'intéressent. Donc on voit que ces normes évoluent dans un sens où on va davantage demander aux tiers d'identifier les inégalités, les déséquilibres et d'agir, donc c'est-à-dire d'adapter le processus, de veiller à la qualité des échanges, de veiller à la qualité des accords. Mais comment le faire en maintenant cette posture de neutralité ? Parce qu'en même temps, on nous demande soit de moins influencer le processus parce qu'on est neutre, soit de plus l'influencer parce qu'il existe des déséquilibres entre les parties. Donc ça peut devenir un dilemme pour les praticiens et praticiennes, et différentes recherches, auteurs, autrices proposent de repenser ces cadres avec d'autres concepts comme de neutralité empathique, militante, impartialité inclusive, que j'aurai évidemment pas le temps de présenter ici. Donc le premier axe sur les tensions normatives et le deuxième axe sur les dilemmes justement pratiques que peuvent vivre les conciliateurs ou les médiateurs dans le domaine. Donc, c'est de comprendre, on sait que les conflits qui sont marqués par des asymétries font partie des conflits les plus difficiles à traiter en médiation, en conciliation. On sait aussi, grâce à certaines recherches, que le déséquilibre entre les parties, il affecte directement la capacité des personnes à participer au processus de résolution des différends. Donc maintenant, ça va être de comprendre est-ce qu'il existe déjà des recommandations formulées pour les tiers, médiateurs et conciliateurs pour agir malgré cette tension normative et on voit qu'il existe déjà des recommandations, mais je dois passer rapidement. Et ensuite, la phase 2, c'est d'aller sur le terrain et d'observer concrètement les conciliations lorsqu'elles sont menées dans ce contexte spécifique du logement et de l'inégalité et de mener des entretiens avec les conciliateurs pour voir comment eux, ils définissent leur posture et comment ils agissent face à cette tension entre la neutralité et le besoin d'équilibrer les processus. Donc, j'arrive au bout de mes 10 minutes, puis je serais heureuse de répondre à vos questions si vous en avez, mais aussi si vous avez des commentaires, étant donné que le projet démarre, ou des contacts qui pourraient être intéressants, surtout pour le volet empirique, comme vous comprenez, qui viendra dans un deuxième temps. Voilà, merci.
Merci, Adeline. Next up, we have Marianne Popescu on screening for safety and justice, advancing family mediation with the Help M Toolkit. Marianne is the Executive Director of the Ontario Association for Family Mediation and an accredited family mediator.
Thank you so much, Lee. It's a pleasure to be here. You are a very friendly bunch. This is my first time at this conference, and I was told you were friendly, and you have been, so thank you very much for that. What I'm here to present on in 10 minutes is a conversation. And so in front of you, you will have a printed copy, it's also available online, of the Help M Toolkit. So what it is, and I will just advance the slides. here. And I'll try to keep to my slides so I can keep to time, but I'd love to have conversations with you all. But essentially, the president of OAFM, now Justice Archana Medekar, who was appointed the day we finished writing the document, we were driving in the car, and she kept getting a phone call from a 705 number. She kept saying, I don't know the number. It was Attorney General trying to contact her, and I implored her to answer, and she did not. She said, it's not in my context, I won't answer. So Justice Archana Medekar and I undertook writing this adaptation of the HELP toolkit about a year ago. The Department of Justice published, you may have heard of it, the HELP toolkit, which was for family law lawyers to help identify family violence at the time. And from the standpoint of being a family mediator and being in my role at the Ontario Association for Family Mediation, we looked at the HELP toolkit and realized that we could do a little bit more deepening on what it's like to have a mediative conversation. We actually started with mediation as the core for our research and consultations throughout the province and throughout Canada. And we quickly learned that we needed to take a mediative approach, which meant expanding the scope to collaborative professionals, judicial conferences, settlement conferences, and such. So what we've created is a conversation. Trying to stick to my slides, the core problem is that traditional assumptions about mediation, that mediation doesn't always fit. And I've spoken to a number of you already and saying, oh, there's always this, there's a screening out for family violence. And so what we've written here is a tool to think about process design, to think about identifying safety, to think about actually at really the root of it is to have a conversation, human to human, to talk and listen, to understand what's happening for that person, for that family, from a trauma-informed lens and a culturally informed lens as well. So that's what we tried to do in the tool, and I'll just go forward. So what the HELP-M is a process, safety, and ethical decision-making framework. It's a continuous tool. So at OAFM, we always say screening is an ongoing process, so we don't stop screening. We don't say this is like a one and done tool. You may be familiar with other screening tools where, like the MASIC or the MASIC-S that sort of ask you to ask a bunch of questions, which are all excellent questions. However, it leads the reader to think that's it. You've done your screening. Has your client been screened? Tick, mark, check. And so what we're saying is this approach is a continuous, ongoing, relational tool. And it's grounded in trauma-informed principles and culturally appropriate accommodations. And I want to say that this HELP-M toolkit was an 11-month project. We have applied for funding again to expand, to explore other pathways. So it was a very quick frisk around the province and country, and what's before you is to us, I think, the seed of what the HELP-M is. So it's important to be distinct about the fact that the HELP-M is not an investigative tool. It is not a tool about looking at, like, is this a credible witness, for example, or is this person's claim true? Is what they said about what happened in their family the truth? And so we're not looking at this screening tool as a way to determine the truth and not sort of mechanically follow a screening tool. So the core really of the HELP-M is actually about process design. So as family mediators and as other mediative professionals know, we can actually adapt the process in a number of ways. And so we think about ways to create a safer space for the families that we're engaging with so that they can speak more freely, they can engage without sort of worried about being pressured. And this sometimes can mean when we talk about screening out, we actually talk a lot about pause instead of termination and getting those additional supports for the family. And in the toolkit, you'll see a list of, we tried to make it Canada-based. We are an Ontario-based organization. There's quite a few about Ontario there. But trying to do a wraparound of services so that when someone comes to us, that when the Attorney General spoke about, like one resource to go to. It would be nice if many of us as professionals did have the access to resources for families that come in front of us that, you know, we don't have to solve all the problems, right? I don't do risk assessment as a family mediator. There are professionals trained to do risk assessment. There's tools that are created to do risk assessment. And so we need to know how we can work together to envelop the family in the support that they need in order to move forward. This is so if you see in the screening toolkit, one of the main things we heard was that time is an issue. So in the middle of the toolkit, we've, what is this called? Laminated, so thank you so much, some pages that are really the core of the tool. And this is what we started with. So this in the second laminated page is really talking about the cycle itself. And the first thing is readiness and appropriateness. So those are the first two phases. Is your client ready for this process? Is it the most appropriate process for them to engage in? And is there something else that you can do? And then I talked a little bit already about process design, about continuous screening. And the other factor that we don't talk a lot about is how do we safely terminate a case? How do we create a space where, you know, maybe we've decided that this case won't go forward, and how do we make that safe for the person who may have disclosed information, and sort of navigate that for the family without outing someone around some information that they wished to remain confidential. So again, we're taking a trauma-informed approach. We're looking at, a question I train in family mediators as well, and a question that we have a lot of the time is like not, what's wrong with you, but what happened to you? Tell me your story. Tell me the foundation. What was your life like before you got here? And I think all of us know in this room that we can have a meaningful conversation in just a few moments with people, right? I can meet you and ask about your dog, or and I can hear about your family and sort of start to learn a little bit about who you are. And that doesn't have to take hours. It's not therapy that we're engaging in when we're asking about what brought you here, what's your foundation. And I think that trauma-informed approach and that building rapport, we found a lot in the research, and even as my role as a family mediator as well, when you slow down to be very curious and ask questions with respect about what it is that the person has told you, that we can create this dynamic where we have rapport, that maybe they're not telling you what happened today about, the family violence that they've experienced, but they might tell you tomorrow. And so taking this trauma-informed approach is very important. And then understanding trauma and mediation. In our role as mediators, it's not our job to sort of push people into a decision-making place. We're there to notice and respond, to slow down, to help people who are in a state of dysregulation to have time to become more regulated, to feel ready for the conversation. And really this, again, it's a human-centered approach, what we're all here to do, thinking about how to connect human to human. And maybe today isn't the day for you to do a big mediation and decide on child and spousal support and what happens with the matrimonial home. Maybe you need to pause. Maybe you have to cancel the meeting or postpone to next week. And that is throughout the help toolkit. You'll see that's written about there. A culturally congruent approach, like thinking about, there's several questions and there's the full Help toolkit and the core screening tool, and you'll see that we're trying to talk about identifying how are decisions made in your family? Like what is the usual way that decisions are made? And this can be influenced by culture, this can be influenced by interpersonal dynamics of the family and a number of things. So thinking about who they are in their family, how decisions are made, and normalizing it and not judging for, maybe someone comes to you with a decision that is made, I have 1 minute left, I'll talk about that a little bit later, hopefully. What this looks like, respecting cultural communication styles, and we'll talk a little bit about that piece. Just quickly, this is probably one of the most interesting things that came out of this toolkit was that we created an Indigenous pathway, that we recognize that, within the screening tool itself, there's a note to say, if someone identifies as an Indigenous person, and then there's a whole extra set of questions around indigeneity and looking to make sure that we meet the needs of the family that's in front of us. And I think I will stop there so that we can have a nice chat. Thank you so much.
So we had, like I said, a few preloaded questions. I think if we advance the PowerPoint, we'll get to those. But I want to encourage people also to get up, and we have the 2 mics in the room. I was going to start off with just one general one to pepper our panelists with, which is, what reforms have you identified that would improve access to justice? That might require another 3 days. But if you have any particularly key hacks, access to justice hacks that you might have identified in your work, and I'm going to merge it with question 3. Are there any of them that you think would help address the particularly acute access to justice challenges and barriers of trans, two-spirit, and non-binary folks? We can just go back in our same order, if you like.
Can you go reverse
we can go in reverse order over here.
I'm going to put you on the spot.
I think that the relational approach to the Help Em toolkit and the conversation and the openness, I think, is what is, it's threaded throughout the Help Em toolkit and really threaded throughout our roles as family mediators to actually see people for who they are and ask questions with respect and curiosity. And information. So being prepared for, the answers that you may get and doing a little bit of research ahead of time, making people feel comfortable. I think this is a big part of our roles in family law, family justice, as family mediators, to actually demystify things. So many times as a family mediator, people will ask me, can I do that? And my answer is always, you haven't broken the law. You're just getting separated, or you're involved in this process. So I feel like the more we can connect to humans and hear about their story, I think this does goes a long way to creating open space. The other thing I think we can do is signal, even within the Help Em toolkit, or signal ourselves that where we may have knowledge or that we may be sharing a safer space is also important signals to put even on Zoom when we use pronouns, when we have, Zoom screens, when we're celebrating Pride Month coming up, and these sorts of events where we're really showing that this inclusivity lives in our hearts. I think that helps people to feel a little bit more comfortable in sharing. Yeah.
Thank you. And not everyone has to answer every single question, but would anyone else like to take that one on? Yeah, Adeline.
Mais je trouve que ces questions se rejoignent. Puis dans le domaine de la recherche sur les modes de prévention et règlement des différends, longtemps, la recherche a servi à analyser le développement de ces processus, puis mais aussi à l'accompagner, à analyser la légitimité de ces processus et la place qu'ils pourraient occuper dans le système de justice pour permettre aux personnes d'avoir un meilleur accès à la justice. Mais aujourd'hui, l'étape à laquelle on est rendu, selon moi, c'est de poser la question de la capacité des personnes à participer effectivement à ces processus. Puis c'est lié à la troisième question, parce que quand on interroge cette capacité, l'étape d'après, c'est d'identifier les groupes pour lesquels c'est le plus difficile de participer à la résolution de leurs conflits. Et ça amène à tout un tas de réflexions sur comment on encadre ces processus, comment on les pratique, les stratégies qui sont déjà mises en œuvre et les stratégies qui pourraient venir supporter justement cette capacité à participer à la résolution des conflits pour des procédures plus justes et plus équitables.
Charlene, I think you were...
Yeah, I was just going to add... So I think using more restorative processes in all of the work that we do. I think there's a conference this fall, I think the CIAJ has, that's really focused on restorative work. I think that's pretty critical. And I think really creating through multiple pathways of addressing people's unmet legal needs is that they see themselves reflected. And that you have to... community needs to see themselves reflected more fully in the justice system, throughout the entire justice system, and you feel safer when you are working with somebody who really, truly understands you and sees you. You know, so often, Charlene and Crystal often form bridges. I didn't talk about that, but they really are a bridge because for the client, they feel very safe with them. But it's the bridge that they connect the client to the lawyer, to the justice system, to the social worker, to whoever else within that system that the family's working with. So I think those two pieces are really critical. And I do think we need to focus a lot more of our research and work outside of the court system. I think still too much of even what we talk about is that there's so few people that actually make their way to court and to the litigation process. And we really should be looking, I think, more at reforms that support more community-led solutions.
I concluded a bit on this point, but I think just symbolically, the blanket permission of age-based discrimination in human rights legislations, we should rethink that. I'm not making the case that, toddlers should drive, but, but just tolerating all forms of age discrimination against kids, I think we need to step away from that. I think we need to, seeing kids as right holders, I think that would help, and seeing age-based discrimination against kids, and then collecting data, intersectional data. So you asked about, access to justice for, trans kids was like first and foremost when I was thinking about this research. Human rights tribunals, commissions are described as the final refuge for the disadvantaged and the disenfranchised, and trans kids in Alberta. Who's defending them, and the role of parents with regards to that. So that is one kind of. We were presenting our research recently to ombudsman offices, and they asked us about how do you navigate these recommendations and your research with the role of parents and. Kids having to depend on their parents or legal guardians to affirm their rights. And I think that's one missing piece in our research that, we should have maybe talked more with practitioners before we designed our research. But I think particularly about trans kids whose parents aren't stepping up to enable them or empower them in affirming their rights, or who even might be violating their rights, and what is the role of commissions and human rights tribunal, and even providing legal education, but also access to justice for those kids. So that's a missing piece in our research, but it's something that's great concern to me. Yeah.
And questions from the audience, I think. Yeah, go ahead.
Ready to jump up. Thank you so much. My name is Aaron Leakey. I'm with the Access to Justice Center for Excellence, doing a PhD that implicates some work around intimate partner violence. Some of it has implicated consensual dispute resolution processes in their appropriateness. I'm also the manager of training at Media BC and a practicing family mediator. So it's good to have this dispute resolution emphasis here on the stage. So what both Marianne and Adeline's presentation did for me is rethinking some fundamental values around mediation. So I noticed in the kit there's a rethinking of self-determination. I noticed, Adeline, in your presentation, there's a rethinking of this foundational concept of vulnerability. So I'm just wondering if you could reflect on those. And over for Anne, if I can get as many questions in as at once. In the family locked modernization okay, you're aware of this in British Columbia. Oh, okay, it's just in the Family Locked Modernization Project that they've published a pre-report. They're thinking of expanding the voice of the child. And so I'm wondering what your reflections would be on what that might look like, and if you could reflect a bit on participation and vulnerability, in how these two things work together, how we conceive them, what they should be, how we understand the inclusion of a vulnerable participant. Easy.
Shall we start on this side?
So self-determination is a really important factor for family mediation specifically, because we often talk, one of the things that we go to school for, we learn in training, is screening out for family violence. And I think that this does two things. One, it makes people performative in traditional screenings in family mediation. So it can make someone want to pass the screening and therefore not disclose what's happening to them. And the other thing it does is it prevents access to a service that could be adapted to meet the needs of the family. So I think that self-determination is key, and that why should we be the ones to hold the decision around solely the decision around which process is right for which family at what time. And I think, yes, we need to step in, and yes, termination, safe termination is part of the cycle. It is only part of the cycle when you've had that relational experience with the family and that they get to choose, and we get to listen and hear and adapt. And, a family mediation that's done in a shuttle style, different days, different times, no one's aware of the Zoom meetings of each other, and there's no contact, I would say that could provide some more physical safety than some courtroom proceedings. So I think that there's self-determination, and the person's voice and the voice of the child too are things that are very pivotal to our work as family mediators.
Toute l'idée de déconstruire un certain nombre de mythes qui supportent le domaine du règlement des différends dans la présentation. Le mythe de la neutralité, le mythe de l'autonomie des parties qui est basé en grande partie sur une égalité supposée entre les personnes. Puis c'est ce qu'encouragent les normes actuellement, c'est de préserver cette égalité, mais en fait, dans un certain nombre de litiges, elle n'existe pas, cette égalité entre les parties, donc on la suppose. Et donc pour répondre plus spécifiquement à la question, dans ce projet, ça va être de comprendre quand est-ce que la vulnérabilité empêche la résolution du différend, et donc il vaut mieux mettre un terme au processus et envisager d'autres voies, et quand est-ce que la vulnérabilité demande d'adapter le processus de résolution des différends, et à ce compte-là, comment l'adapter, et il existe déjà un certain nombre d'exemples, donc ce serait de rassembler ces exemples et d'aller plus loin en voyant dans la pratique, au Québec, notamment au tribunal administratif du logement, si on peut trouver d'autres formes de stratégies, puis y penser. Mais par exemple, les programmes en matière de logement ont montré qu'au-delà de la résolution formelle du différend, le médiateur ou la médiatrice peut jouer des rôles en situation de déséquilibre entre les parties qui sont très intéressants, comme par exemple le fait de favoriser l'accès à des programmes d'accès au financement en matière de logement pour les personnes précaires. Mais ça suppose que la personne tierce, médiatrice, elle ait cette connaissance de ces programmes gouvernementaux ou non gouvernementaux de financement du logement, où ça peut être de permettre, au-delà complètement de la question de régler le conflit, mais une meilleure compréhension des différences culturelles peut-être entre les personnes qui sont dans ce conflit, et donc une meilleure inclusion sociale. Donc ça nous amène à repenser la logique même des processus de résolution des différends qu'on a très centré sur régler le conflit, mais voir dans le rôle que peut jouer le médiateur ou la médiatrice, est-ce qu'il n'y a pas d'autres aspects qui seraient intéressants en situation de vulnérabilité. C'est ça.
Charlene, did you want to jump on that question? No, you're good. Okay.
My head is still turning. I'm going to provide probably a really unsatisfying answer to your question, because I think what we learned in our research is that the mechanisms we were looking at were not really adapted to children. And so my answer, I think, will be that I think these processes probably have more to learn from family law. And how do you create safe space for kids to speak and participate when maybe their interests are at odds with their parents, and how do you make sure that their participation is age appropriate and all of that, because the mechanisms we looked at when kids are driving the bus, right? So these are what we were looking at are cases, child initiated complaints, I think we have more to learn about from family law in these mechanisms than the other way around. That's what I would say. So yeah.
See, we have another question. Go ahead.
I don't mean to be, so my name's Mary Birdsell. I'm the executive director of a legal clinic in Ontario called Justice for Children and Youth. And I just would really, really caution in the access to justice context about trying to learn anything about children's participation and dignity in the context of family law. I think it's the context in which we do almost the worst job of respecting the autonomy, agency, and dignity of children, and in particular from sort of an access to justice lens. And one thing that I would just add is that quite a while ago now in Ontario, Tribunals Ontario had created a social justice sector, and within that there was the creation of a child sector. So the Human Rights Tribunal, some education, there are sort of 3 education tribunals in Ontario, and they included the Social Benefits Tribunal and the Landlord-Tenant Board. So that there was this real focus created around adapting tribunal processes for children's agency and individual use, including having suspended the requirement of a sort of, I'm going to use litigation guardian broadly, and then as a political matter, all of that was just completely disbanded. So I think it's a really, I mean, obviously children's rights are sort of the fundamental content of my day job work. But I think that so many of these kinds of spaces and places get created and then disbanded. So it's a struggle, I think, and I'm interested to hear what other people have to say about, how we can continue to learn from things that get destroyed, because I think there's a lot of remaking the wheel that we are constantly called upon to do. Let's find innovative things. Let's do where we actually don't need a lot of innovative things. We just need to more fully support the brilliant things that all of you have talked about, that are happening, as opposed to do things on a project-by-project basis. So that was the nature of my question, but I couldn't resist the opportunity to slag family law.
For your comment, and really also for that piece of knowledge that only comes from experience about the context of family law. I mean, it was a bit of an off-the-cuff remark, but so thank you so much for saying that. And we'll look at these best practices of the tribunal, because when we asked the survey, that didn't come out, so thank you. Yeah.
I think that's part of my question, though. It's true, like, we have a whole bunch of new tribunal members, or we have people who, and they just missed it by a day or two is often what happens, and it's challenging.
We should talk over coffee. Yeah, thank you. Thank
So
you
many
much.
coffee dates after
I'm really grateful for your comments.
We have time for one more question, and I see one more person standing up, so over to you.
Sorry, I just had the surgery on my gums this morning, so I might be speaking sideways. We can't forget the social determinants in whatever we do, because there's people here that are not here, that should be here today and for the rest of the conference. So when you're talking about the logement, you have to look at food security, housing security, because that's the center of what you're doing, but how to give it back to people and empower them in time. And that's one thing I'd like to also say is change the people around the table every so often, because having the same people around the table will give you the same results every time. So mix it up every so often. It helps to diversify the conversation. Thank you.
Thank you. Yeah, go ahead.
It's just to say thank you, because this is great, and I think sometimes when we share these resources, it has more effect than anybody sort of knows it does, and we're all across Canada here. So
Nice.
I really love the comments about the shuttle mediation, because as a lawyer and a mediator, I see all the time, an intimate partner violence going straight into the courts. Just want to thank the panel. It was really a great presentation today and lots of useful information. Thank you.
Thank you so much.
She did my job for me. You have the QR codes on the screen. The big one, I think, is for the Help M toolkit, and the smaller.
No, that's just for you.
Oh, that's the Trans Access
Except
to
there's a
Justice,
typo,
okay.
but that's okay.
The Trans Access to Justice report from CBA in collaboration with Transforming Justice Out of Ontario is what the QR code is for, and it has a lot more on what I was talking about a little bit earlier and what the panelists have addressed. And we are, I don't want to make you late for lunch, so I will wrap it up there, but I want to invite you to join me in celebrating the wonderful work of our panelists.